May it please your lordship, my lord. Since this case has been pending at the Debt Recovery Tribunal at Guwahati, and we are pursuing the case over there also, so I pray your lordship to kindly allow me to withdraw my petition with liberty to file afresh.
That's good. You have read the provisions, isn't it? There are some
Yes.
provisions. And there are certain Supreme Court judgments also.
Yes, my lord.
When there is a specific provision under the statutes, you are supposed to go there. Okay, please write down, as prayed for by Mr. P.C. Thangmoya, Learned Counsel, for the petitioners. The writ petition stands dismissed as withdrawn. You want liberty, or we'll ask you to approach the appropriate forum?
With liberty, my lord.
Okay. However, liberty is granted as prayed for, to file afresh if so advised.
Deeply obliged.
For orders, item number 3.
Lordship, I'm appearing on behalf of my senior Mr. Bilaram, as he's still on medical leave, my lord. So, if the matter may be kindly fixed on Wednesday, 30th of October, my lord.
This is the case diary.
Yes, my lord.
What is there in this?
Nothing much, my
Have you
lord.
gone through it? Last time I had made an observation
Yes, my lord.
that you will obtain instructions whether you require this person to be in custody or not.
Yes, my lord.
Is he required or not?
I got the instruction from the case IO and he mentioned that the appellant is in voluntary pension now, and they have no objection if he is released on bail.
So we'll dispose it of. Why Wednesday?
Dispose, my
Yes,
lord.
yes, my lord.
What is the charge here against PC Act?
Yes, my lord, PCA.
What is the stage of the investigation otherwise? Ms. Banesiami, have you seen the case diary?
Yes, my lord.
The last entry was on
6/9,
6/9.
2024.
6/9. Today we are in 28/10.
Yes, my lord.
Nothing has happened in between.
No, my lord.
Is this the latest?
This is the latest, my lord. The case IO has recorded their statement on 10/5/2024.
10/5.
Yes, my lord. 10/5.
10/5. Name of the petitioner is
Case Ayang.
K. Zanyangi. Serial number 4. This petitioner was working in the secretariat.
Yes, my lord, as an LDC,
From which department?
School education.
school education.
Okay. Anything has been seized from the school education? Yes, this one. 6/9. Your good name?
Lomo Maralte.
Heard Mr. Lomo Maralte, Learned Counsel for the petitioner, and Ms. Banesiami, Learned Additional Public Prosecutor. Stop. On 14/10/2024, court passed the following order. Please abstract. this order. Okay. Next para. Today, Ms. Vanna Isiami, learned additional public prosecutor, has produced the case diary. Stop. A perusal of the same indicates that the case IO has recorded the statements of 6 persons on 10/5. No, on 10/5 you cancel them. 6 persons, including the instant petitioner, on 10/5/2024. Stop. Thereafter, on 12/7/2024, the case IO has seized 69 numbers of Finance Department documents from the Deputy Secretary to the Government of Mizoram Finance Department in presence of reliable witnesses. From the Secretariat, not from the in the Secretariat, instead of from in the Secretariat. Full stop. Thereafter, on 6/9/2024, the case IO again seized certain related documents from the School Education Department from the possession of the Under Secretary to the Government of Mizoram School Education Department in the Secretariat as well. Stop. Thereafter, no further process has been recorded in the case diary. Stop. The learned additional public prosecutor submits that as the statements of the persons concerned, including the petitioner and also the documents related to the case, have been seized by the case IO, the custodial interrogation of the petitioner may not be required. Stop. She also submits that as the petitioner is now a pensioner, court may consider passing appropriate orders as it deems fit and proper. Next para. Upon hearing the learned counsels for the parties and upon perusal of the materials available on record, including the case diary, it appears that custodial interrogation of the petitioner may not be required. Stop. Accordingly, the ad interim pre-arrest bail granted to the petitioner on 14/10/2024 is hereby made absolute. Stop. It is, however, made clear that the petitioner shall extend full cooperation in the investigation and shall appear before the case IO as and when she is required to do so. Next para. With the above observation and direction, the bail application stands disposed of as allowed.
Obliged.
You oblige, Madam.
Item number 5.
Yes.
This is an appeal against the order and decree dated 25/9/2023 passed by the Civil Judge Senior Division 3 Aizawl. And also order dated 26/9 of 2024, passed by the Civil Judge Senior Division 3 Aizawl. Your Lordship, IA number 177 of 2024 is application for continuation of delay, and IA 178 of 2024 is application under section 151 CPC for leave of the court for filing appeal.
Leave to file appeal, is it required? Under what provision?
Under section 151. My lord, the appellant is not a party to the civil suit.
Oh, that's why.
Yeah.
Okay.
If
Third
I-
part, this is a third party appeal?
Third party, yes,
Okay.
my lord.
Now, what you have just said is just the other way around. Leave application is 177. Sorry, 178, sorry. Leave is 178,
178.
condonation is 177.
17. Yes, my lord.
You said condonation is 178, is it?
I may have mistaken.
Condonation is first. So that is 177.
Yes, yes, my lord.
So notice will have to go. Today is the first time it has come, isn't it?
Yes, my lord.
What is your good name?
Lalbek trauma.
How many days delay?
304 days. My lord, while serving notice, allow me to make amend of my pleadings in page number 3 of my petition,
Which petition?
condonation. From line number 3 from the bottom.
Page number 3.
Yes.
Where?
Bottom line number 3.
Yes, bottom line.
Mistakenly recorded, written as 7-4. That should be read as 4-4.
4-4.
Yes.
The thing is that you see, this is the only mistake appearing.
Yes, yes, my lord.
In fact, for any correction, you are supposed to file an IA. This is the circular that has been issued by the High Court.
Yes, my lord.
All right. I think we'll issue notice in both the leave and the condonation. Heard, Mr.
That'll be a trauma.
There'll be a trauma. Learned counsel for the applicant who submits that by filing this application, the applicant seeks condonation of delay how many days you said?
304.
Condonation of 304 days delay in filing the connected appeal against the order dated 25/9/2023, passed by the Court of Civil Judge Senior Division Roman 3 Aizawl in civil suit number 40 of 2023. Next para, issue notice to the to the respondents returnable by 3 weeks. How will you serve notice?
That's my direction. They are the residents of Aizawl. Yes.
I know. Can you
Dusty.
serve by way of
That's
Dusty?
yes, we can serve.
Returnable by 3 weeks. Okay. The applicant is allowed to serve notice to the respondents by way of Dusty, which should be through the registry of this court within a period of 10 days from today. Stop. The applicant shall thereafter file an affidavit as proof of service. Why don't you replace this page number 3? Print it out again. Can you replace
My
it?
lord. Yes, my lord.
Next para. Since there is a typographical mistake in paragraph number 2 of the application as regards the date 7/4/44, is it?
Yes, for 4.
4/4/2024 being written as being typed as 7/4/2024, comma, the applicant is allowed to replace the page. When will you replace? By today,
Itself, yes.
within the course of the day. Next para, list the matter again after 3 weeks.
Obligement.
Then in the leave application, again you write 178, okay? The earlier one was IA 177. Now it is 178. Heard Mr. Lalbir Tuama, learned counsel for the applicant, who submits that by filing this application, the applicant craves leave of this court to file the connected appeal as a third-party appeal. Since the applicant is aggrieved with the order dated 25/9/2023 passed by the civil judge, by the Court of Civil Judge, Senior Division, Roman 3, Aizawl, in civil suit number 40 of 2024. Next para, issue notice to the respondents, returnable by 3 weeks. Stop. The applicant is permitted to serve notice to the respondents by way of Dasti through the registry of this court within a period of 10 days from today. Stop. The applicant shall thereafter file an affidavit as proof of service. List the matter again after 3 weeks. Yes.
For admission, item number 2.
Lordship, I'm for the respondent number 5 in this matter, and if I may kindly be granted further 2 weeks' time to submit our affidavit in opposition.
Respondent number 5.
Yes, my lord.
Who is respondent number 5?
Number 5, Lal Kamlo. Private.
Private respondent, my lord.
Nalkam Loka. CRP. What about the others? 1 to 4. Any counter? Then number 6.
Number 6 is a pro forma respondent, my lord. She has, in fact, has nothing to do with the present case.
But she's
Since she
made a
was the-
party.
Yes, she was made a party because she was a party in the court below.
So
And
have
that's why
you,
she was made up.
has notice been served to her?
My lord, we have.
When was it served? Okay, AD card returned back but without signature.
Yes,
Last time there was an observation.
right, my lord.
Please write down. Parties are represented by the respective counsels except for respondent number 6, who otherwise is said to be a pro forma respondent by the counsel, learned senior counsel for the appellant. Stop. As paid for by Mr.
Lomo Maralte.
Lomo Maralte, learned counsel appearing for respondent number 5. How much time?
2 weeks, my lord.
Further 2 weeks' time is granted for filing affidavit in opposition. List the matter. No, before that, similar chance is granted to the state respondents for filing counter affidavit. Next para, list the matter again after 2 weeks.
Obliged, my lord.
Obliged.
For hearing, item number 6.
You were supposed to file an IA.
I have attended, I have prepared everything, but I was objected by the registry, my application. I'm not be pursuing the IA.
Okay.
Although it has been filed in the prescribed manner, it is subjected by the registry.
What reason why it was objected?
If I may, for this one.
No, you just tell us why it was objected.
The applicants,
Which part?
They asked for additional documents. We are seeking for deleting 7 petitioners, names of 7 petitioners, and the application itself is filed by them. But in addition to that, they are asking for certificate by signing by all the petitioners whom we sought to delete.
Okay.
But this application itself is filed by the applicant's petitioners.
And who has signed it? One of the applicants.
One of the applicants
Okay.
amongst them.
You have not enclosed the certificate saying that we want to withdraw from this case.
No, my lord.
That is why.
Because the applicant, yes, man. The applicants which we sought to delete themselves were the applicants of this application
Okay, but only one of them has signed, isn't it?
in the affidavit,
That's why.
but authorized by the other applicants.
Authorized to file, but that authorization is not there, isn't it?
Not the authorization, my lord. They're asking for that they have actually applied for this deletion.
Okay, probably it's as a matter of abundant precaution. That is why. Abundant precaution. Today you withdraw it, tomorrow somebody comes and says, I never withdrew it like that. So that one can show that, see, this is what you have signed for withdrawal. Anyway, you're not pressing it otherwise,
Yes, ma'am.
isn't it? How many petitioners are there?
7.
How many wanted to withdraw?
There are total 35 petitioners. 7 of them want to withdraw.
Okay, out of 35, 7 wanted to withdraw.
Yes, my lord. I'm sorry, 8. 8. Total
Okay.
8.
All right, so what is your case?
Yes, my lord. The petitioners herein were initially appointed as the legal service staff.
When?
They were appointed during the year between 2011 and 2017. Most of them were appointed on 2011. And this is the there is a first ground litigation, my lord. If I may take a lordship to page number 101. 101. There's another writ petition which was earlier disposed by this honorable court. Page number 101.
See, these petitioners were appointed as what?
They were appointed on temporary basis, initially on
In
contract
against
basis,
what post?
against the post which was created under the 13th Finance Commission, funded by the 13th Finance Commission.
What is the post?
The posts are Group C and D, B, C and D.
B,
UDC,
B also.
yes, my lord. UDC, LDC, and Group D.
Group C and D. Okay. Third Finance, what do you say? 11th Finance Commission.
13th Finance Commission.
13th
my
Finance
lord.
Commission.
Under the 13th Finance Commission, there was a sanction for creation of ADR Center.
Under the 13th Finance Commission.
Yes, my lord. And in order to implement the ADR Center, the present petitioners have been appointed. And the 13th Finance Commission is for 5 years. And after the expiry of 5 years, my lord, the Mizoram State Legal Services Authority had earlier filed WPC number 189 of 2015 for continuation of required fund for running the State Legal Services Authority under the state. And the same was disposed on 9/7/2018, page number 101. And the direction herein, amongst other, is to create 38 posts. Direction was made to the state respondents to create 38 posts and to fill up the same in accordance with law at the earliest. Page number one.
Just read paragraph 2. Let us try to understand
Yes, my lord.
your case.
Yes, my lord. The instant writ petition is filed by the Mizoram State Legal Services Authority, which was constituted by notification dated 11/9/1997 under the enabling provisions of the Legal Services Authorities Act 1987. Thereafter, the District Legal Services Authorities for all the 8 districts in Mizoram was constituted by notification dated 2/6/2010. In order to facilitate the functioning of the state authorities, 38 numbers of various posts was created for the Alternate Dispute Resolution Center and the District Legal Service Authority by notification dated 1/6/2011. However, the posts were created on co-terminus basis with the 13th Finance Commission grant to be filled up on master roll basis from the date of engagement up to 28/2/2015. That since the 13th Finance Commission was due to come to an end shortly, the petitioners through each member secretary submitted a proposal that the aforesaid posts created on co-terminus basis be converted into temporary basis under the state fund of plan or non-planned head of account, so that the functioning of the State Legal Service Authority and the District Legal Services Authority would not be hampered. However, such proposal with detailed justification and organization chart submitted by the petitioners was rejected by the state respondents by holding that co-terminus posts are only terminable on termination of the scheme, besides holding that there was no proper justification. That after several requests were made to the state respondent authorities, that the functioning of the State Legal Services Authority would be hampered without the sanction of 38 numbers of various posts at the end of the 13th Finance Commission, that is on 28/2/2015. The state respondents in the Finance Department by order dated 12/5/2015 made an allocation of fund during 2015 to 16 for improving justice delivery in the state to be regularized in the regular budget 2015 to 16 positively. The case of the petitioners, however, is that such arrangement hardly meets the requirements of the petitioners. In fact, Article 39A of the Constitution of India mandates that the state shall secure equal justice and free legal aid to its citizens on the basis of equal opportunity, and particularly to those who are economically backward and to those with other disabilities. Furthermore, Section 6, subsection 7 and Section 9, subsection 7 of the Legal Service Authorities Act 1987 provides that the administrative expense of the state authority and the district authority, including salaries, allowance, and pensions payable to the secretary, officers, and other employees, shall be defrayed out of the consolidated fund of the state. However, in the instant case, the state and district authorities have only been made to depend upon the Finance Commission grant for its functioning, which is only for a specific duration. Therefore, the constitutional scheme on legal service cannot be carried out with such limited source. Mr. So-and-so, counsel for the respondents, has submitted an office order dated 1/9/2017, issued by the Secretary of Government of Mizoram, Law and Judicial Department, bearing memo number so-and-so. Here, my lord, the office order dated 1/9/2017, the Governor of Mizoram is pleased to accord sanction for creation of the following 38 various posts under the Mizoram State Legal Services Authority as under.
Yes, so the posts have been created.
Yes, my
Then
lord.
the writ petition was disposed of
Yes, my lord.
and with the direction to fill up the post in accordance with law.
Yes, my lord.
Now, thereafter, what happened?
Thereafter, my lord, the petitioners have been requesting the respondent authorities repeatedly to consider their case by absorbing them, appropriately absorbed in the newly created sanction post. And in the meanwhile, my lord, their services were also converted into a master roll basis, which was extended from time to time. But, well, they were having a legitimate expectation that their case would be favorably considered, my lord. The respondent had issued the impugned extension, the impugned letter, which is in page number 118.
118.
Page number 118, NSS 16, my lord.
Yes.
This is ID number such and such, dated 11/4/2022. Approval is hereby conveyed for extension of engagement of the following 36 master roll employees under the Mizoram State Legal Services Authority with effect from 1/3/2022 to 28/2/2023, or till regular appointment is made, whichever is earlier, on the condition that no further extension shall be considered, even if recruitment process for regular appointment is not completed by 28/2/2023. Here they have given ultimatum up to 28 February 2023. And on the following page, my lord, 119, the finance concurrence for a period up to 28/2/2023 is also enclosed. And the Legal Services Authorities Act 1987, my lord, more particularly at section 28, which is at page number, I have also enclosed, section, page number 48.
So, this engagement was extended till 28/2/2023.
Yes, my lord.
What is the present status now?
As a result of interim order given by this court, my lord, we are still retained in the post. And there's also a subsequent development that we are given extension up to February 2025. Our grievances is then, my lord, the section 28 of the Legal Services Authorities Act 1987 section 28.
Yes.
Section 28. The state government, in consultation with the Chief Justice of the High Court, may, by notification, make rules to carry out the provisions of this Act. In particular, and without prejudice to the generality of the foregoing powers, such rules may provide for all or any of the following matters. E, my lord, E. The conditions of service and the salary and allowances of officers and other employees of the state authority under subsection 6 of section 6. In short, my lord, the Act provided that there should be a specific recruitment rules which should be made by the state government in consultation with the Chief Justice. And accordingly, my lord, earlier the state respondents had, the respondent authorities had made a draft recruitment rules, which I have enclosed starting from page number 120. In the draft recruitment rules, my lord, they have made the provisions for absorption of the existing incumbents to the newly created post under the State Legal Services Authority.
Where is that?
Starting from page 120.
120.
This is the draft proposed recruitment rules during that point of time. And the rules may be called Mizoram Legal Service Rules, Group B Recruitment Rules 2021. If I may take a lordship to page number 124, this is in continuation of these draft rules. 124. In the column 10, my lord, column 10, method of recruitment, absorption 90% from the incumbents who are currently engaged on master role, provisional employees under the ADR Center at Aizol, Lunglei, DLSA office at Champhai. Likewise, my lord, they have earlier made a draft recruitment rules for enabling all the petitioners to absorb
Manoj, I'll supply my copy. I'll get a photocopy later.
Just a minute. Mr. Victor,
Yes, my lord.
your expectation was to be absorbed
Yes, my lord. Correct.
because of having rendered so many years. But now the rules have come. Draft rules provided absorption. It was not cleared. Ultimately, perhaps the new rules have come up wherein there is no such kind of provision for absorption. So, that being the position, I think you have no case at this as of today. It has become infructuous.
My lord,
Insofar as, unless you now challenge that rule, saying that this is not correct because we are like this, the rules cannot have been framed. You may need to go in that direction.
I understand that, my lord.
With the present set of documents, there's nothing left to be decided. If they have come with rules, they will say that we have the rules now. We have to fill up according to the rules. Now, insofar as your extension granted by the state is concerned, that will remain. You will continue till when you are extended. That will not be disturbed. But insofar as recruitment that may be required, I think you cannot stop that at this stage.
If this Annexure 21 and 23, which are impugned in the one-time adoption, this letter may be set aside, my lord.
Which one?
Annexure 21 and 23, the letter which granted a one-time adoption of foreign rules.
This is no longer required. We definitely will set it aside
Yes, my lord.
if you want to. It's no longer required because now they need not look for here and there. They have their own rules. I have sent the court master to look for the rules. I believe I have a copy somewhere. So
Okay.
let me find it out. Miss Linda, do you know the name of the rules? What do you call the rules? You don't have a copy, a soft copy also.
I have the notification on this.
What do you call the rules? What is the name of the rules?
This rules, Mizoram Law and Judicial Department, Group B post, Mizoram State Legal Services Authority Recruitment Rules 2024.
Mizoram State
Legal Services Authority, bracket Group B post, Recruitment Rules 2024. That is for Group B, and there is another one for Group C.
Same thing.
Same, and another one for Group D.
And when was it notified?
August 29.
This is
Effective date?
30th, 29 August 2024.
It was notified on 29th August 2024, and it came into force with effect from 38
38
2024.
2024.
The date of its publication in the Gazette. 38 30.
38/24.
Yes,
And the notification is?
29th August
29 August 2024.
2024.
Okay. Have you got it? Yes. Group B. Call the steno, please. Yes, please write. Heard Mr. Victor L. Ralte, Learned Counsel for the petitioners, and Ms. Linda L. Fumble, Learned Additional Advocate General, Mizoram, for the respondents. Stop. By filing this writ petition, the petitioners have challenged the approval conveyed by the DPNAR bracket ARW for extension of engagement of 36 muster roll employees under the Mizoram State Legal Services Authority bracket MSLSA close bracket with effect from 1/3/2022 to 28/2/2023 or till regular appointment is made, whichever is earlier. Stop. It was also noted that no further extension will be considered even if recruitment process for regular appointment is not completed by 28/2/2023. This you'll get at page 118 if you want to refer. 118. Next para. The petitioners have also challenged notification dated 24/11/2022 bracket annexure 21 by which the Governor of Mizoram was pleased to order one-time adoption of the Mizoram Ministerial Service Rules, 2021 bracket MMS Rules 2021 close bracket for filling up of 10 posts of UDC and 12 posts of LDC under the MSLSA. Stop. Challenge has also been made to a similar notification dated 24/11/2022 bracket annexure 21 close bracket did I say notification? Instead of notification, you write communication. A similar communication dated so and so in respect of Group D posts under the MSLSA. Stop. The petitioners have also made an interim prayer that till disposal of the writ petition, the advertisement number 1 of 2022-2023 dated 6/12/2022 bracket annexure 28 be stayed. Next para. Brief facts of the case is that the petitioners have been appointed temporarily on muster roll basis, is it? In Group C and D posts between the years 2011 and 2017.
Group B, C, and D.
Okay, B also. Group B, C and D. Under the years 2011-2017. Under the MSLSA. Not under, you write in the MSLSA. Then now under the 13th Finance Commission. To stop, the 13th Finance Commission was for 5 years and their appointment was coterminous with the said commission. Stop. After the expiry of the term of 5 years, the services of the petitioners have been continued from time to time. And in fact, till date, despite the approval given on 11/4/2022 up to 28/2/2023 on the strength of the interim orders passed by this court. Next para, the grievances projected by the petitioners is that they have rendered long years of services after their initial appointment, and that there should be some provision made by the respondent authorities for their absorption to their respective posts. Stop. Initially, the respondent authorities had made a draft rule by which the provision for absorption of the incumbents to their respective posts was provided up to the extent of 90% of the posts, while 10% were 10% was reserved for direct recruitment. However, the draft rules could not be finalized, and therefore the impugn notifications dated 24/11/2022 came to be issued to adopt the MMS Rules 2021 as a one-time measure for filling up of the posts of UDC, LDC and Grade 4 under the MSLSA. And following which, the advertisement dated 6/12/2022 came to be issued. Stop. Aggrieved, the petitioners are before this court. Next para, Mr. Victor L. Ralte, learned counsel, submits that the petitioners have been rendering their services since their initial appointment with the expectation that their services would be, with the expectation that they will be absorbed to their respective posts. Stop. He submits that under Section 28 of the Legal Services Authorities Act, 1987, bracket, Act of 1987, close bracket, the state government has the power to make rules in consultation with the Chief Justice of the High Court. Stop. The respondent authorities, therefore, came up with the draft rules by providing that 90% of the incumbents currently engaged under the MSLSA in different districts and that you rewrite again under the MSLSA the rest you cut, comma, ADR center and DLSA offices in various districts would be absorbed
In respect of Group B, that is in respect of Group B.
in respect of
Group B,
B.
yes, my lord. There are 3 draft rules for B, C, and D.
So what is the difference?
In C and D, there are 100% for absorption.
In respect of Group C and Group D. To stop that, in respect of Group B posts, 90% of the incumbents already working would be absorbed to their respective post, and the remaining 10% be engaged by way of direct recruitment. Stop. However, without proceeding any further with the draft recruitment rules, the respondent authorities have come up with the notifications dated 24/11/2022, wherein they have sought to adopt the MMS Rules 2021 as a one-time measure. Stop. By adopting the said procedure, the interest of the petitioners have been adversely affected, and there will be no opportunity for them to be absorbed to their respective posts. Stop. The Learned Counsel, however, submits that in the meantime, certain developments have taken place, and the state government, with the approval of the High Court, with the approval of the Chief Justice of the High Court, have come up with the Mizoram Law and Judicial Department, open bracket, Mizoram State Legal Service Authority, close bracket, open bracket again, Group B posts, close bracket, recruitment rules, comma, 2024. B will be within single inverted comma. Stop. Similar recruitment rules have been made in respect of Group C and Group D as well. Stop. The Learned Counsel fairly submits that in the said recruitment rules, which has come into force with effect from 30/8/2024, comma, there is no provision for absorption of the incumbents who are already working under the MSLSA. Stop. He submits that the respondent authorities in the DPNAR, ARW, and the Finance Department nevertheless have extended the period of engagement of the petitioners up to 28/2/2025. I repeat, 28/2/2025. Stop. The same was communicated by the Under Secretary to the Government of Mizoram, Law and Judicial Department on 25/9/2024 to the Member Secretary, MSLSA, Stop. The learned counsel submits that, such being the position, the engagement of the petitioners may not be disturbed in terms of the said extension order. Stop. He also submits that the impugn notifications dated 24/11/2022, adopting the MMS rules 2021 should be 21 as a one-time measure should also be set aside. Next para, Ms. Linda L. Fumble, learned additional AG, submits that in view of the relevant rules for Group B, C, and D having been framed in terms of Rule 28 of the 1987 Act. In terms of the Act of 1987, there would be no requirement to rely upon the MMS rules of 2021 in order to fill up the posts under Group B, C, and D category in the MSLSA. Stop. She also submits that in view of the approval granted by the competent authority for extension of the incumbents currently serving under the MSLSA up to 28/2/2025, their services will not be disturbed. Next para. Next. Upon considering the submissions made by the learned counsels for the rival parties and upon perusal of the materials available on record, including the new rules which have been framed in terms of Section 28 of the Act of 1987 for recruitment to the Group B, C, and D posts under the MSLSA, it only appears that the instant writ petition has been rendered infructuous. Stop. Stop. The question of adopting the MMS rules 2021 now will not arise, and therefore the impugn notifications dated 24/11/2022, bracket Annexure 21 and Annexure 23. Are hereby set aside. Stop. The interim order passed staying the advertisement dated 6/12/2022 is hereby made absolute. Next para. The respondent authorities are now directed to proceed with the recruitment for filling up of the posts in Group B, C, and D category, strictly in accordance with the new recruitment rules, which has come into force with effect from 30/8/2024. Stop. It is needless to provide herein that the petitioners shall be allowed to continue in their respective posts up to 28/2/2025 in terms of the extension granted by the respondent authorities themselves. Next para. With the above observation and direction, the writ petition stands disposed of.
My lord, if I, that second last portion of the direction passed by your lordship regarding the direction to fill up the post strictly in conformity with the rules, that may prejudice the petitioners praying for relaxation of the provisions of the rules.
How will it prejudice you? Rules is there, and we cannot say that don't fill it up against the rules. I said fill it as per the rules.
It may prejudice misinterpretation on the part of the respondents for
How?
exercising relaxation clause.
You want me to make an observation for relaxation?
Yes, my lord.
Let it remain, whatever I said, let it remain.
Yes, my lord.
I'll make one more observation
Yes, my
that
lord.
the employees may apply for a relaxation
Yes, my lord. If-
and the same may be considered. Next para. Before parting with the records, it is further provided herein that as some of the petitioners may be interested to participate in the recruitment process to be initiated as per the new recruitment rules, they having rendered long years of service in their respective posts and apparently overaged as on today. And may not apparently and may also have been overaged to participate in the recruitment process. Stop. Therefore, in the event they wish to participate in the selection process, but on account of their overage are not able to do so, they may submit appropriate application for condonation of their age to enable them to participate in the selection process. And in the event of submission of such application, the respondent authorities concerned shall consider relaxing their age. Is there any provision for relaxation otherwise? Generally.
Yes, my lord. Section
Nine.
9.
As may be permissible in law. comma, regard being had. No, as may be permissible in law. The rest you cut. 9 is similar for all the rules.
No, my lord. The thing is that, my lord, there are 3 rules herein. Only in respect of Group D, there is age relaxation only beyond 35.
Where?
In Group D post, my lord, there is, as per the usual other recruitment rules of the state government, they were given relaxation up to 5 years beyond 35.
No, that I was not saying that. I was referring to this rule 9.
All section 9. All
9
rule,
is
all rule 9.
common for all the rules.
Yes, my lord.
Yes.
In view of rule 9, in all the new rules meant for Group B, C, and D. All right.
Deeply obliged.
इसको लाना साथ में है एक मिनट